Thanks a lot for staying with us. You're still on to this morning on ITV. My name is Anulu Stevens. And as we tend to, the momentum builds up to the election in Edo State, and of course the one that will be happening in Ondo State pretty soon. There's a whole lot of conversation from the judiciary and of course the sustenance of democracy right here in Nigeria. Well, you will agree with me that the judiciary is a critical pillar of a country's democratic system, responsible for upholding the rule of law, protecting individuals' rights, and ensuring that justice is dispensed fairly and to all parties involved, in the electoral process. That is why joining me this morning in the studio is Mr. Mike Igini. He is the former INEC resident electoral commissioner for Edo and Akwa Ibom State, here with me live in the studio. Good morning, sir.
Good morning. It's my pleasure to be here.
Okay, so now let's get into it already. What is the connection between democracy and, of course, the judiciary, especially in Nigeria?
Yeah, but first and foremost, I want to thank the management of ITV Radio for this invite. For quite some time, I've been off the radar. But I understand this is the maiden edition broadcast from Lagos.
Right.
And I'm very delighted that, I'm part of this historic moment that we are now in the center of excellence. And I also want to use this opportunity to say a happy birthday, in advance to Sir Chief Dr. Gabriel Osawaro Benedo Ezama of Benin, the founder and chairman emeritus of ITV Radio, for being one of the first indeed to have the private broadcast licenses in Nigeria. One of the first to also have the certificate for a private university for his great vision. So really, you are welcome to Lagos. This is where actually Europe began since 1997.
Right.
Now, having said that, with respect to the subject, the rule of democracy and the rule of law, I must say this here that the judiciary is the bedrock of any democracy anywhere in the world. Whether the institution representing democracy will have a hopeful future in Nigeria will depend on the judiciary standing tall and mighty in defense of democracy and the rule. A proper understanding of the preeminent role of the judiciary in any party democracy is indeed a precondition for an optimum functioning of democracy. But regrettably, tragically, and painfully, that has not been the same in our country historically in the post-colonial Nigeria. And context is very important as we continue to make our effort in a very difficult task of nation building after 64 years. Is that democracy is the bedrock of any judiciary. And the first early victim of the subversion of democracy is the rule of law. Because the rule of law is a graceful ornament to an ordered society. In fact, philosophically, it is said to be the corrective capital of a free society. But right here, as we have seen elsewhere, regrettably, this is my own constituency. I will say it painfully that the kind of courage that my constituency, the judiciary, demonstrated during the military period, when the journey of Nigeria and prospect of democracy was less certain, since the advent of democracy, the judiciary have not been able to do so. As you could see, that we have got to a point in our country today where who becomes a candidate in our democracy, who wins an election, are also not determined by the courts and people. But the fact is that Nigeria cannot be in autarky of how mature democracy had evolved. Because what is clear is that when we make reference to the US, to United Kingdom, Europe, what is evident is that for every civilization, there was a primitive past. Nigeria appears to have remained or remains stuck in its primitive stage, in the sense that electoral UK, England, and America in the 19th century were the most electorally corrupt countries in the world, including Russia. Russia is still there. At that time, talking about judiciary, there were vote buying, the kind of thing you see today going on in the country since we've practiced democracy. But First Republic to date, we have not moved away from those things. Now, talking about democracy, judiciary being the bedrock of democracy. In England, there were electoral manipulations. There were incidents of vote buying, violence in England as at that time. Now, during those periods, the election petition matters were not decided by the courts. The idea was that in any society there must be an institution that we must turn to. And around the world, one very important arm of government to which all must bow must be the judiciary. And so in England, so that we must learn from where we are right now in moving forward, as we talk about the elections that are coming up, either the off-season elections and the one that will come sometime in 2027, the point is that we have got to a point in our country, talking about judiciary, where the kind of judgment that comes from the courts, people see them as a conspiracy against the people. Yes. We have got to a point in our country where people no longer see the courts as the last hope of the common man, but they see God as the last hope of the common man. And so the lesson that must be learned from what happened in England is that because of the corruption in England as at that in 19th century, it was decided that if politicians will corrupt electoral process, when the election petition goes to what they call the parliament by the House of Commons, that determine petition, because of the fact that the Conservative Party or the Labour Party, whoever that was, whichever party that was in majority, there was no electoral justice when people carry petition through to the parliament. Because of that, it was decided that the court in England must not be involved in election petition. That was the beginning. But at some point in time, because there was no electoral justice, people were no longer interested in election in England. It was at that point that it was decided, following what happened in Australia, when they came up with what they call the secret ballot system. The secret ballot system was intended to cure election rigging in Europe, everywhere, which has been adopted universally today. Okay. It was brought up in 1856. United Kingdom only adopted it in 1872, at which time they agreed that the only way to survive democracy in England was that we now needed the court to come back. But to do so, they now provide what they call legal safeguards to protect judges, because they believe that politicians can corrupt judges. Because today in our country, if you look at the Apple barometer, painfully, this is the only profession I belong to. Judiciary is now associated massively with corruption, which was the case, which was what England, the English people prevented and did that very well.
Right.
And that's why, for a period of almost 100 years, until 2010, after every election in England, for almost 100 years, nobody goes to court in England because the decision of the people is decided finally and conclusively at the polling unit. But the point I was trying to link up to understand, to underscore the significance of judiciary being the bedrock, being the greatest pillar of democracy, is the fact that when the court was now decided to step in, we now had what we call the 1882 Act, as well as the 1883 Act subsequently, that ensured that every election manipulation rigging in England, the court was enjoined to interpret it strictly to the extent that if you commit electoral fraud in UK, vote buying, you'll be expelled from Parliament for 6 years, or by the 1883 Act, you'll be banned for participating in politics for life.
Okay.
That was how England changed the situation, and that's why up to today, there was now a return to the polling unit. The polling unit, polling station, whatever you call it, was now the final place where the will of the people is determined in England. Okay, that is the pathway we must go, and that is why judiciary must stand tall and mighty in defense of the rule of law and democracy.
All right, thank you so much, Mr. Mike, for that, that basis, because I feel we actually needed to set, the pace right as regards the conversation on ground, talking about, beyond reforms, the importance of sustaining democracy in the judiciary. So during the course of the conversation, you said something as regards how we get to see some influence happen, during the course of the electoral system, especially here in Nigeria. So how can we, attain that level of independence of the judiciary, especially in the country?
Well, first and foremost, when we talk about independence of judiciary, today in our country, the only arm of government that is independent across Nigeria is only the executive. Legislation and judiciary, they are not independent. Because if you want to determine, even maybe to some extent, maybe the legislation. But judiciary, you'll recall that President Buhari signed an executive order for the autonomy of judiciary. You happen, state governors all rally round to oppose it. They don't want the independence of that arm of government. And when you want to determine the independence of any arm of government, you look at the mode of appointment, you look at the issue about funding, particularly funding, which is an instrument of control. We really do not have that at the moment. And that is why you also find that, given the example of Nigeria, with what we are going through in terms of our disappointment with my own constituency, is the fact that if you look at the issue about reform, what else are you talking about reform again? As we speak today, I can confirm to you, from 2010 till when I left office and up to this moment, we have processes and procedures to address historical challenges of election service delivery in our country. By the virtue of the 2022 Act, for a period of 23 years, most of those provisions that have been used to rig election in the past were all addressed in the 2022 Electoral Act. INEC, before we left office, out of the 153 provisions that you have in the current 2022 Act, INEC made a proposal of 91 provisions, out of which 48 were accepted in the current Act. But what did the judiciary do? From the primary process, it was very clear that my constituency and all Nigerians who listen to me all through the period of mobilizing the country for the 2023 elections, I was always talking about my constituency, saying that, look, for a credible election in our country, for a sustainable democracy, you require the trinity of the three. One, the election management body. Two, security agency. And three, and perhaps far more important, is the judiciary. But what happened? The judiciary destroyed the process for the moment of the primary process. Because when we saw the attitude of the court, painfully with the apex court, it's very, very clear. And I'll give you a few examples of that. Now, you see, the first stage, or one of the stages, very critical, was issue about party primaries. To deal with the issue of internal party democracy in Nigeria, the 2022 Act took care of that. Section 84, subsection 1 was very clear as to the fact that you must conduct party primaries. And section 29, if you are to submit the names and you want to sponsor for election, those people must pass through what we call primary by virtue of section 29 of that act. To complement that, the Chief Judge of the Federal High Court, because all pre-election matters now are the party primaries and all of those things and all that, they have to go to the Federal High Court. The Honorable Justice, the Chief Judge of the Federal High Court, issued what he called practice direction for the speedy determination of those matters before elections, and brought a new innovation to the effect that anybody who is aggrieved with the outcome of the political primaries, you commence that process by way of what you call originating summons. That is to say that you don't need to call witnesses because of the fact that once the document showing how it was conducted, particularly when some other video and all of that, it will not be necessary. That also complements section 137 of the Act itself. So the fact that where there is a complaint of non-compliance, once the original or the certified copy discloses that allegation of non-compliance, you don't need to call oral evidence because witnesses were strategy to either compromise witnesses during the primary, whatever, and all that, or the model will disappear, and that will stop the whole thing. Okay. But this is what the court did. So all the people that filed who were aggrieved out of their party primary in the country, they filed that process as required by law, written law, the practice direction, that by way of originating summary does not require what we call witnesses. What happens? From the Federal High Court, Court of Appeal, all of them agreed. But when it got to Supreme Court did look at the merit of all people who came to the court for justice. What did Supreme Court do? Supreme Court, on a technical ground, that you approach this court by way of originating summons, which was correct according to the party direction. But no, you should have come by way of writ of summons that you need to call witnesses. So the Supreme Court of our own country didn't look at the grievance of the people, but went on a technical ground. When that happened, I saw that there was danger ahead. And that also followed other subsequent type interpretations, right, all of which do not accord with the spirit of the law. And that is where I feel that for democracy to survive in Nigeria, we must be very careful. Judiciary must be ready and do what the English courts did to safeguard democracy in England, in America, because the backbone of the American democracy is because of the judiciary. Hardly will any issue arise that will not be determined.
So with all of these things that you've outlined so far, that happened so far in the country as regards the judiciary, especially in the Supreme Court, would it be right to say Nigeria, and especially the common man, has lost confidence for the judiciary? And then if yes, how can the judiciary begin to ensure that an average Nigerian or whoever, a litigant, goes to the courts to file in petitions, ensure that they get justice to the core? Speaking about the lack of confidence on the part of the judiciary.
The greatest calamity that will befall a nation will be when a citizen says they have no confidence in the judicial system. We must not get to that stage. Because when we get to a stage where...
Do you think we've gotten there?
Oh, at the moment.
We have.
Nigerians, when it comes to issue about elections, and the judgment will be coming from the court, the masses of Nigeria, they believe that these are conspiracies against them. In fact, today, it will be somebody of intellectual suspects that will parade the shibboleths that the judiciary is the last hope of the common man. At the moment, on the streets, the feeling is that the court, it's now God and not court that is now the last hope of the common man. This is why I call on my colleagues, both at the bar and the bench, that in every society there must be somewhere to turn to. Wherever there is even in the state of anarchy, we must stand tall to defend democracy, because the whole embrace of democracy is essential because it brings about participation and accountability to the process of human development.
Okay, so let's talk about the issue of corruption, because it's no longer news that when we talk about some parts of the country's policies and all, we begin to hear corruption every now and then. So the issue of corruption, and especially in the judiciary, how can that label be removed completely from the judiciary?
Well, first and foremost, judges are not from a different planet. The corruption we're talking about, pervasive in a country, is a reflection of our society. Regrettably, we have some of the finest judges in our country. But painfully, the corruption of a few of them seem to overshadow, seem to rob off some of the judges' finest we have in our country. In England, in America, it is very rare, it is unheard of for people who willfully commit crime to say, let's go to court. Politicians are afraid of judges in England, but in Nigeria, politicians are not afraid of judges in Nigeria.
Why do we
They are the first to tell you, you go to court. You see, in England, the court can never be a safe haven for corrupt politicians. But in Nigeria, the courts are now the safe haven for corrupt politicians in our country.
Well, let's not also forget.
That is the problem.
Yes. But just to chip in this a little bit, let's not also forget that some part of the Electoral Act actually stipulates that you have a right to move to court in case you're not happy with the results of the election.
That is the challenge. Enforcement. I have told people talking about reforms. I said, what reform are you talking about? If anything at all, you see, in criminology, it has been established that every wrongful act that is rewarded, that is not punished, will be repeated. That is what is happening in our country. I have just told you that in England, either by yourself or through your supporters, you try to rig election, you'll be banned for life for participating in politics by virtue of the 1883 Act. The previous 1882 was expulsion for 5 years. In England, you cannot hear a politician say the kind of thing they say here. They respect judges there. In America, a Supreme Court invalidated cancelled election because the law provided that the ballot paper must be folded in a particular manner to avoid fraud. But in South Carolina, the EMB some years ago folded it in the other way around. Supreme Court allowed that election in South Carolina. But in Nigeria, we now talk about substantial compliance. We accommodate some level of corruption in our system. As a matter of fact, before the 2023 election, for instance, I was telling the whole world that by virtue of Section 134, subsection 2 of the 2022 Act, the National Assembly clearly stated that every directive, instruction by INEC with respect to the conduct of the election that is outside the Act will not invalidate election, which will be excluded, forgetting the fact that INEC, by virtue of paragraph 15 of the Constitution, had the power to make regulations. And so, I like any guidelines, they are part of the law. Where you now have an act that stated clearly that a directive instruction for INEC should not be obeyed, what do you expect to happen? And most of these that went to court refused to look at them. Remember, when we introduced Carida in 2011 and 2015, what was the argument? Go to the case of Peter Side and Wiki. The court said, oh, Carida was a beautiful instrument, but that they were more interested in the analog, ordinary, what they call a manual register, and that we should have that Carida written in law. What happened? They forgot the fact that even before that time, Section 160 of the Constitution, God bless Jonathan, President Jonathan effected what he called the first alteration to the fact that the power, we're talking about the Constitution, not the Act now, before 2020 election, that whereas all other bodies established under Section 153, executive bodies, whereas they can act under the direction of the president, but with respect to the Independent National Electoral Commission, its powers to make rules or otherwise regulate its own procedure shall not be subject to the direction of the President of the Federal Republic of Nigeria. That provision was there. Elections that were taken to the court with respect to Carida. What happened? The court looked the other way around. The recent argument, absolutely nonsensical. So the fact that beavers require another law. Which law are you talking about? By virtue of Section 60 of the 2022 Act, the presiding officer was expected after the close of the poll to transmit the results in the manner prescribed by the Independent National Electoral Commission. The question you now ask, did INEC prescribe a manner to transfer or transmit the result? The answer is yes. You go to paragraph 38 of INEC regulation and guideline. As it affects section 64, subsection 5, 4, and 5, which enjoin border collation officer to transmit. Somebody is telling you today that, oh, there was no law for transmission. They are already there. But by virtue of section 134, section 135, it was deliberate that this should not be part of the whole thing. This is where we are. Right. And so my call, my charge is that judiciary, the society, you have a bigger role to play. Lawyers. And I've made the point before that if a country is capable of dying, Nigeria will die because of the failure of my constituency to stand tall and mighty in defense of the rule of law and democracy. Because without the rule of law, electoral contest will be nothing but the crude deployment of force, as we have seen in many places, where we now hear about gun democracy is now what we have in our country. And so, judiciary must stand up. That is the only pathway to get this right.
Now, speaking about standing up, as we tend to wind up the conversation, I would love us to critically look at the issue of overburdening, from the aspect of the Supreme Court, because we saw during the last hours of the former CJN, that's Justice Kayode Ariwoola, they talk about how the Supreme Court is overburdened. Can you talk a little bit about that? How do we even get there?
Very clear. As a matter of fact, first and foremost, stop interference with INEC work by politicians, so that the will of the people expressed should be determined finally and conclusively at the polling unit without people going to court. I just told you, for almost 100 years, there was no post-election education in England.